Hi, I'm Christopher, owner and founder of Brine Consumer Law here in Worcester, Massachusetts, where I exclusively help people find solutions to unaffordable debt and debt-related problems. Today I'm going to be going through one of the most frequently asked questions that I get here in my office, which is what the difference is between a Chapter 7 bankruptcy and a Chapter 13 bankruptcy. If you're currently considering filing bankruptcy, you've probably discovered that Chapter 7 and Chapter 13 tend to be the most common types of bankruptcy that people file for. And at least at the beginning of the case, both Chapter 7 and Chapter 13 really follow the same structure to get the case filed. In order to file a case, you'll have to file a petition with the bankruptcy court that lists all of your income, all of your expenses, all of your assets, liabilities, and certain types of transactions that you might have entered into over the past few years. There's also a trustee appointed in every case, and the trustee serves as the appointed representative of your creditors. And you have a meeting with that trustee about a month after the case is filed. And the meetings themselves tend to be fairly quick, usually about 5 or 10 minutes long, and your attorney would attend the meeting with you as well. And the trustee really has two main jobs in the case. Their first job is to make sure that you're not doing some sort of bad deed. You're not lying on your petition, you're not hiding assets, or doing some sort of other bad act that might impact your ability to get a discharge from the bankruptcy court or discharge of any particular debt. Most often, though, their role is really their second job, which is looking to make sure that the creditors in your case get as much money as they're entitled to under the Bankruptcy Code, under the bankruptcy rules. And what that means as far as a Chapter 7 and Chapter 13 really varies. So in a Chapter 7, most cases are really just a straight discharge of debt. It typically takes about 3 months from start to finish. You'll probably look online, you'll see that a Chapter 7 really is considered a liquidation of assets. In most cases, though, there's no property that's lost or sold to creditors. And the reason that is because there's different types of laws under both federal law and state law. Those are called exemptions that you can use to protect certain amounts of value in your stuff. So there's specific exemptions for equity in your home or in your vehicle, value of jewelry, of furniture, appliances, clothing, bank accounts, retirement accounts, and many others. There's also what are called wildcard exemptions that you can use to apply to anything else that you might like. So when you combine the specific property exemptions and the wildcard exemptions, most cases tend to be what are called no asset cases, where everything is fully protected, there's no property lost, and you basically just proceed to discharge. The cases are held open for 60 days after that trustee meeting. If there were going to be any issue in the case, as far as an objection to discharge, that's the time period it would come in. And the cases would enter a discharge somewhere after that 2-month period. So like I said, it's typically about 3 months from start to finish. On the other hand, a Chapter 13 case is really structured as a payment plan over several years, usually between 3 and 5 years, depending on your particular circumstances. There's no involuntary loss of property in a Chapter 13. So if you do have some piece of property that might be liquidated in a Chapter 7 that you really want to keep, what you could do in a Chapter 13 is keep that property with the caveat being that at least as much as creditors would have obtained in a Chapter 7, you have to pay back in your payment plan under a Chapter 13. If there otherwise wouldn't have been an issue in a Chapter 7 for you, your monthly payment plan really should be based on what's affordable under your budget. There's a lot of different criteria that go into figuring out exactly what your payment has to be each month. But the general rule, like I said, is that it's supposed to be affordable based on your budget. So if, for example, your budget shows that you can afford a 10-cent dividend, 10 cents on every dollar to each one of your creditors over the term of your payment plan, then that's what you pay, and that's all the creditors are entitled to get. Once you complete that payment plan, you would then get a discharge similar to the discharge that you would get in a Chapter 7 case. And just like in a Chapter 7 case, you can't ever be contacted by those creditors to try to collect them thereafter. There's a lot more details that go into figuring out exactly what might be the best option for you, and what a Chapter 7 versus a Chapter 13 might look like for you. But at least at a basic level, that's really the main difference between a Chapter 7 and a Chapter 13, with the Chapter 7 usually just being a straight discharge of debt over a few months, and a Chapter 13 usually just being a repayment plan over a few years.